program today. Just a few housekeeping rules. I want everybody to know this program is going to be recorded so that we can provide it to all students at a later date. We have you muted upon entry, so please use the chat function for any questions that come up during the program, and I will be sure to monitor it and make sure that the questions are answered. So I'd like to introduce everybody here today to our speaker and presenter, Casey Patillo de Cusar. Casey is a 2005 graduate of Albany Law School. She's also the founder of the Women's Leadership Initiative at Albany Law School, and we're delighted to have her here with us today to talk about corporate law, the anatomy of a deal. Casey advises corporations, boards, Casey is a partner at Cahill, Gordon, and Rindell. And she advises corporations, boards, private equity firms, and family offices on complex business law matters, focusing on mergers and acquisitions and other strategic transactions. She also advises on acquisition finance, growth equity, and other minority investments, governance, disclosure, and compliance matters. Casey was named one of 2020's most influential women in mid-market M&A by Mergers and Acquisitions magazine. She's also recognized as a rising star by IFLR 1000 and a leading lawyer by the Legal 500, with one client remarking, "Kimberly is terrific. She's a practical leader focused on executing transactions for her clients." Casey was named among the notable women in law in 2020 by Crain's New York Business, and in 2018, she was selected as a rising star by the New York Law Journal and an emerging leader by M&A Advisor. Suffice it to say, we are truly hearing from an expert today on corporate law, the anatomy of a deal. So with that, Casey, I will let you take it away.
Awesome. Thank you so much, Mary, for that wonderful introduction and for hosting me today and for all of the work that you and the school have done on getting the Women's Leadership Initiative up and off the ground running, and the summer series, which I think is going to be great. So I'm going to share my screen, see if I can do it twice. Awesome. Okay, you guys can see that, right? Okay, excellent. I'm going to move Mary's beautiful face to the side so she's not blocking my presentation. Okay, wonderful. Okay, so we're going to talk today, and my understanding is that everybody who's listening in are either current students or recent grads, and so early in your career. So I'm going to give you the overview of just kind of corporate law, what corporate lawyers do, and in particular walk you through a deal that is kind of all encompassing of a bunch of different things that people do within the corporate law realm. And along the way include things that junior associates would be working on in each of these different functions and capacities. And if at any point people have questions, please use the chat. Mary will interrupt me and I will try and answer questions real time, and certainly happy to chat at the end. So I want there to be time for questions, so I'm going to dive right in. So corporate practice is very, very broad. You have non-transactional work and you have transactional work. And I spend my day doing both. Some lawyers who do corporate work spend their day primarily on non-transactional, and I have lots of partners and folks who do just transactional all day, every day. I do a hybrid, which I love. It's what I want my practice to be. And but at the end of the day, it's just advising companies on whatever it is they need advising on from a corporate law standpoint. So my non-transactional day could look like SEC filing. So for public companies, helping them with their 10Ks or their 10Qs or their 8Ks or other filings that are required when you're a public company to put out disclosures to your investors. It could be questions on their code of ethics policy or their insider trading policy. It could be board matters and advising the board on a particular transaction or something that they're considering, or their fiduciary duties, which we'll talk about in a little bit. It could be employment matters. It could be tax strategy or tax matters. Cybersecurity right now is a huge area and a huge topic that a lot of companies and boards are talking about, and how to maintain safe systems, and what happens in the event that they do get hacked or have an issue, and how to interact with the FBI and other governmental organizations. And it could just be day-to-day contract stuff, how they're dealing with their vendors or their suppliers or their supply chain, and anything in between, anything that you imagine could come up in the life of a company. That's what a non-transactional corporate lawyer does. And so they truly are generalists and need to know a lot of different areas of law, and be able to advise their client on a bunch of different areas, and talk through them, and really understand what the client needs, and what their risk tolerance is, and what their ultimate goal is, so that you can advise them appropriately. Because how I advise one particular client on their executive compensation arrangements or on their governance matters is very different than another, based on how the shares are held, what their board structure is like, what business line they're in, and various other factors. So so you have to be mindful of that, and it's not just a one size fits all on the non-transactional side. On the transactional side of the house, those are deal lawyers, and they just do deals all day, every day, or like me, you do some deal work and some non-transactional work. Deals can be anything. It could be a debt deal, which is lending, just taking a loan effectively. It could be security, so issuing notes or other debt instruments. It could be a merger and acquisition, an M&A transaction. It could be a minority investment or some other equity cash infusion. It could be a bankruptcy or some sort of restructuring. So deals can take on a lot of different forms, and corporate lawyers, don't necessarily do all of those types of deals. Some lawyers do just bankruptcy, and that's, pretty particular, and we have just a bankruptcy group at Cahill. Some people do just M&A and other types of strategic investments and transactions. Some people, like plenty of my partners at Cahill, do just lending and securities, or just lending and just securities. So you could specialize in any one of those particular areas, or you can kind of touch all of them. It just depends on the firm and the practice and what you're interested in. So within transactional, I talked a little bit about this. Lending is a loan effectively, and you have various levels of loans for depending on the company size, what they're trying to accomplish, what their credit worthiness is. M&A transactions, like I said, it could be a strategic investment, it could be a minority investment, a JV. It could just be a regular plain vanilla merger or a leverage buyout. Securities, debt securities of varying types, and then you have equity securities, an IPO or a common stock or a preferred issuance. So within each of those transactional practices, there's a bunch of subgroups that you could touch at any given time, or in some cases specialize in. For today's talk, we're going to talk about a leverage buyout of Aramark, which Cahill worked on. Cahill, we do a lot of Aramark transactions. We don't represent Aramark in these transactions, and you'll see what Cahill's specific role is. But the Aramark transactions are fascinating because, and Aramark, for anybody who doesn't know, if you don't know their name, I'm sure that they've touched your life in some way if you've ever gone to a sporting event, because Aramark is the one who provides the food services for stadiums. They provide them for hospitals. They do correctional facilities. They're, a massive organization that does food services in a variety of places. So I'm sure that they have touched your life in some way, or that you've eaten their food at some point in your life. But Aramark is fascinating. So this company first went public in 1959. Then it went private in 1984 in order to fend off a hostile takeover. Then it went public again in 2001. Then it went private again in 2007 in a management-led leverage buyout, which is the one we're going to talk about today. And then they went public again in 2013. So they're one of just a handful of companies that's gone public 3 times. So we'll see what happens next with Aramark. But they've done a lot of different transactions. But this one in particular, this deal where they had a group of private equity firms that came together along with the chairman and the CEO of the company, longtime chairman and CEO Joe Neubauer, came together and decided that they were going to take this company private in a leverage buyout. A leverage buyout is just taking on a whole bunch of debt to buy the stock of a company, and you end up with the same company you had before, but with a bunch of debt and different shareholders. And so this was, at the end of the day, an $8.5 billion deal, almost $8.6 billion. And they did that through bank loans, a receivables facility, they issued bonds, they kept some debt, and then they had an equity infusion by the private equity and Neubauer. And they used it to fund the purchase price, to pay out, to buy out the public shareholders, to refi some debt, to keep some cash, and lawyers are expensive. So to pay a lot of money in fees to lawyers and bankers. So, so that's where they got the money and what they did with the money. But let's dive into the lawyer part of all of this, which is the deal. And so this deal, and like most leverage buyouts, has 3 components. You have a debt deal going on. You have a shareholder approval deal, transaction or process going on. And then you have the merger process going on. So you have 3 things happening at the same time, or roughly the same time. And all of those pieces need lawyers and advisors. So the way that an LBO lines up from a timing perspective is the private equity and Neubauer got together and said, we need to take this company private, and this is how we're going to do it. So they strike a deal, and they need to know they have the money to do it. So they line up the financing through commitment letters. Once they have that in place, then and they start negotiating a merger agreement. They sign the merger agreement, and they get the commitment papers, commitments from the banking institutions who are going to provide the debt. They get all of those signed. And then you start the process of actually drafting and negotiating the debt instruments. You start the process of seeking shareholder approval, which requires filings with the SEC, a proxy statement with the SEC. And then you start the merger related process, which you have a merger agreement already signed, but to actually execute and do a merger requires a lot more than just a merger agreement. And so you have that process going on, all 3 of these at the same time. And then on one glorious magical day, the deal will close. You will incur your debt. You will pay off your shareholders who have since approved the transaction. You will close the merger. And at the end of the day, you have the same company you had before, owned by new people with a whole bunch of debt, and hopefully a better strategy and plan for the go forward operations. And then you continue on the life after the merger, putting aside any subsequent deals that happened or could happen. Life after the merger, the lawyers representing Aramark, you then enter into that non-transactional work that I talked about at the beginning, of just advising them on a day-to-day basis with respect to whatever comes up until the next deal comes along. So this was everybody on this deal. I'll start with Cahill. So we were representing the financing sources, which were led by JP Morgan, who is providing all of this $6+ billion of debt. So we were representing them. The private equity firms that were buying Aramark were represented by Simpson Thacher. Joe Neubauer, who was the chairman and CEO at the time, and who was going to combine with the private equity to buy this business, was represented by Sullivan. Then you have the Aramark. I'm going to skip the special committee for a minute, but then you have the Aramark board as a whole was represented by Skadden, and then a subset of that board, they created a special committee, which was represented by Shearman. And the reason they did that, and you'll see in many deals like this, you create a special committee of completely independent directors. Because Joe Neubauer was the chairman of the board and the CEO, but he was also participating in the transaction by putting in equity and was going to ultimately be an owner of this business. He has a natural conflict. And there were other people on the board who were conflicted in some way, either because they were going to participate or had other relationships. So you create a special committee of truly independent directors who are going to evaluate and recommend the transaction and the pricing on the transaction and so forth, in order to protect all of these shareholders who want to make sure that there's an independent evaluation of the transaction and ultimately, recommend to them a transaction to be approved. And then you have the company, which was represented by Wachtell. And it's interesting, in a transaction like this, the company is involved. Obviously, they're the one, from a diligence perspective, people are doing diligence on them. They have to provide a lot of information. They're the ones negotiating, some of the documents, but it's a slightly odd dynamic in that the company is going to still exist in its same form post-closing. It's just going to be owned by different people. So what the company is looking at is very different than what all of these other entities are looking at in this process. And we'll talk a little bit about what their lawyers were looking at in their primary concerns were in a little bit. And then the last piece of this is Credit Suisse, who they were the financial advisor. They were represented by Cravath. And in any transaction like this, particularly one where you have conflicts, but when you're going out to shareholders to recommend a transaction, you get what's called a fairness opinion. Well, the board gets a fairness opinion. And so they have an advisor, financial advisor, who is independent, who evaluates the transaction and the pricing of the transaction, and it tells the board whether or not they think the price is fair to shareholders, given the circumstances. And then that fairness opinion gets included in the proxy statement, which is the disclosure document that goes out to shareholders. And the shareholders look at that and they say, okay, so we had a special committee of independent directors who recommended it. They were advised by Credit Suisse, who took a look at all of the financial metrics of this transaction and other considerations and said that the price that's being offered is fair to shareholders. That may or may not be persuasive to the shareholders, but it's protection for the board from a fiduciary duty standpoint. And it does give shareholders some guidance that some independent folks took a look at this and thought that it was a fair price to be paid for this transaction. So if you were working at Simpson Thacher and your client were these private equity firms that were trying to buy Aramark, you would do a bunch of the things that are in this box. So Simpson's role in all of this was to advise their clients about whether or not this was a good deal from a legal perspective. So due diligence is something that junior associates spend a lot of time doing in a transactional corporate practice. And it's a critical component of every transaction. And, it requires diligence. It requires a lot of attention to detail. It requires a lot of thoughtfulness and paying attention and seeing how different pieces fit together. So you could be reviewing a document and summarizing it in the diligence memo, and you may see a reference to another document in that document, but that other document wasn't provided to you. So, you have to put in a supplemental diligence request. All of that, the reading of the initial document, the figuring out that, hey, I didn't see this other document, which may or may not be important, and keeping track of what you've seen, not seen, what we still need to request, what's important and not important, which is, a judgment call in many cases, falls on junior associates because it's a very, very time-intensive task. And so if you were a junior associate at Simpson Thacher, you would have been spending a tremendous amount of time at doing diligence on behalf of your private equity clients on Aramark. And so you would be leaving no stone unturned as it relates to Aramark's business. You would look at all of their contracts, their debt instruments, their leases, their vendor and supplier arrangements, their employment arrangements. You would take you'd work with your tax colleagues to take a look at any tax diligence, IP, cyber, just to name a few categories of things that you're going to really dig into so that you could tell your client, okay, we looked at all of these things. This could potentially be an issue post-closing. This is an issue that's going on right now. This is what's going to happen if you do this deal. Many contracts and other arrangements have what are called change of control provisions in them. So once the ownership of the business shifts, it may trigger a default or an acceleration of a particular document. And that's of extreme importance, because if this transaction is going to trigger a bunch of payouts or a bunch of canceled contracts, the deal all of a sudden may not be as attractive. Or what usually happens is you go out and you get consent, or you talk to those counterparties and make sure that they're on board with this transaction before you commit to buying this business. So diligence is a huge, huge component of transactions. It's a huge component of the M&A side of the transaction. It's a huge component of the financing side of the transaction, which we'll get to, which was part of what Cahill Associates were doing on this transaction. So everybody wants to do their diligence and get an understanding of what they're buying. The other thing that Simpson lawyers were doing on this transaction is negotiating all of the documents. So remember, we have these couple of different processes going on at one time. So you have the merger agreement, which is the document pursuant to which private equity and Neubauer are going to actually buy this business and own it. And that's going to have a bunch of different sections in that need to be heavily negotiated. So there's reps and warranties that Aramark is giving that are certifications regarding their business that, Simpson and the private equity want Aramark on the fly paper on. They want them to say, no, we don't have any litigation. Yes, we do have litigation. We've been operating in the ordinary course. Here are all of our material contracts. Here are all of our patents or trademarks or whatever is relevant to a particular business. And so the merger agreement and the disclosure schedules that go along with that merger agreement are a heavy, heavy lift. And junior associates, because they're the ones doing the diligence and they're the ones who now really know this business, spend a lot of time working through the disclosure schedules. So an example of a disclosure schedule statement is set forth, you would have a representation that says, set forth on schedule 4.11 are all of Aramark's material contracts, and material contracts being a defined term, certain thresholds. The junior associate then is going to take that schedule that's provided by Aramark and check it against all of the diligence they did to make sure that, one, it lists all of the material contracts that we're aware of, and also that it doesn't list material contracts that we're not aware of, that were supplied in diligence. And so that's a lot. That's also very time intensive, and another reason why people need to be paying very close attention in diligence and really being thoughtful and mindful about all of this. So Simpson was also negotiating the merger agreement with the company on behalf of their clients and the counterparty being the company, and the disclosure schedules. There's also these other components of the transaction. So the private equity, as their name suggests, is they will be putting in equity into this business. And so that's a whole other set of documents. There's equity financing documents that set forth the terms and conditions and so forth on which the private equity is going to be giving this equity investment. And then there's the debt financing, because as I said, they're going to take on a whole bunch of debt in order to fund part of this purchase. And so there's a whole set of debt financing documents that need to be negotiated. And before you even get to those documents, you have the commitments, which are a whole other set of documents. So you have commitment papers first, where the banks are saying, yes, we're committing to provide you financing subject to these conditions, and the deal terms and the deal actually closing, we're going to provide you the financing and we will be there on closing with the check. So there's 3 sets of deal documents that Simpson was negotiating simultaneously. They have 3 separate deal teams, likely, or at least 2. They usually have the merger team, and then they have a debt team and an equity team. Sometimes the debt and equity folks will overlap, and they might be wearing 2 hats. But there was a lot of work to be done from the private equity, from the buy side here. And then there's also a lot of regulatory work that needs to go along. So a transaction of this size, you need to get Hart-Scott-Rodino approval, which is antitrust approval, and other regulatory, particularly in industries like this one where they may have government contracts, or be going in, they're in hospitals and other regulated and heavily monitored institutions. There's processes that you have to do to approve a change of control or to get the appropriate permits and things like that. And then they're going to own this business post-closing, right? This is now going to be their baby. And so they have to think about life after the closing. And so there's a slew of documents that you need ready to be able to operate this business. The most important of which are typically employment agreements, benefits packages, and so forth, because a business like this, like most businesses, almost all businesses, your greatest asset are your employees. And so this is, even though the company was still going to exist as it existed the day before closing, it'll be the same company the day after. You do have new ownership. You do have a different profile. Now you're no longer public. You have a bunch more debt. There's various strategies and things that were going to happen to this company to now, make it more profitable. And so, but you have to think about your employees, right? You're announcing a deal and saying someone else is going to own this company. Employees are naturally going to worry about, well, what about me? What's going to happen to my salary or my benefits and so forth? And so all of that needs a lot of advanced thought, because you don't want to be on the defensive there. You want to be proactively speaking to folks. So there's this post-closing management of the business, much of which needs to be thought about and addressed pre-closing. So if you were at Simpson, you would be very, very busy on this transaction. So, yeah.
Sorry, before you move on, I'm going to just interrupt. We have a question in the chat from Alicia Johnson. And Alicia, if I don't ask everything you want to know, feel free to unmute yourself, okay? But the question is, are there reasons other than a hostile takeover for a corporation to decide to go private, especially multiple times?
Yes. So, hostile is definitely one, but there's several reasons, and it just depends on the company. But one would be, it's becoming increasingly difficult to manage your business as a public company. And so public companies have a lot of requirements on them. You have to maintain a minimum listing dollar amount to be traded on NYSE or NASDAQ. You have a lot of reporting requirements, your 10Ks, your 10Qs, your proxies, your 8Ks. The cost of being a public company, because you have, your exchange requirements, your SEC requirements, it's just more expensive. You spend a lot more on auditors, you spend a lot more on lawyers, you spend a lot more on insurance. Director and officer insurance for a public company is expensive because the litigation risk profile is so much higher, because you have a large pool of investors. At any point, any of them could become disgruntled or get together a group who's disgruntled. And so it's just you're just higher profile, and so you have more vulnerabilities. And a lot of companies have a hard time operating and being profitable given those increased cost, expenses, and risks. And so some companies are just ripe, absent a hostile situation where you have disgruntled shareholders. Some companies are just ripe to be private, either because they're not making money, because their expenses are too high, or they think they could be more nimble and more flexible as a private company, because you don't have shareholders looking over your shoulder. You don't have to be responsible or to report to anybody. And so you can do a lot more from a strategic standpoint when you're a private company than you can a public company. What you lose is the access to public capital, right? And you lose you lose the high profile nature. That's not the case for Aramark because everybody knew them, but we do have some smaller clients who want to be public because they're trying to, promote a particular product or get their name, more visibility. And so they want to be out there as a public company. I think here they were looking for the more nimble nature of the business, and they needed to recapitalize, reset their capital structure, and be in a position that they could more closely manage the business through Neubauer and the private equity from a strategic standpoint to make it a better and more profitable company. And then once they did that, they went public again and decided to access the public markets. And private equity, usually has some sort of time horizon that they want to cash out. And so that's usually where things head, is that private equity wants to streamline a business, get it back in really good shape, healthy shape. They'll take out some dividends and make some money along the way, but they're ultimately looking in the 5 to 7 year horizon, sometimes a little longer these days, but to cash out, get their money back, and then some, because they've rejiggered this into a much better looking business and, sell it out to the public again, or sometimes sell it to another private equity or others in order to recoup that cash once they've kind of turned things around. Was there another part to that question, or is that it?
You good? I think you're good. We're good.
Okay. All right. So, So the next piece of this, the next party we're going to go to is Wachtell. And let me just check my time because I don't want to run too short on time. Okay. So the next party is Wachtell. They were representing Aramark. They're representing the company themselves. And their heavy lift, they have two heavy lifts. One is the merger agreement and the disclosure schedules that go along with that merger agreement. And so the company is the one who has to, like I said, negotiate the reps and warranties. They're the ones who have to prepare the disclosure schedules. They're the ones who have to prepare all of the diligence that goes, ahead of the merger agreement and disclosure schedules. Some companies require that, need their lawyers to help them with that kind of stuff, to help them organize a data room or to understand what documents are being requested and how far back they should look and whether or not this is something that's responsive or not responsive to the diligence request, and then convert all of that information into disclosure schedules that match up with the reps and warranties that are being asked from the other side. There's covenants in merger agreements, interim operating covenants, so dictating how a company is going to operate in between signing and closing, and there's certain restrictions that are placed on them then, because you sign a merger agreement and then months later you close it, and in that gap period, your buyers want to make sure that you're not doing anything crazy and that it's business as usual. And so there's some restrictions around that. And so Wachtel's primary, initial big lift on this was negotiating that merger agreement with the buyers, so with private equity and Neubauer, and moving that diligence process along. They don't get too involved in the financing aspect of this because, private equity has strong views about what the terms of the debt should be, because they're the ones who are going to own it and have to live with this debt, notwithstanding it's debt of the company. It's some private equity at this point is kind of taking over those responsibilities on behalf of the company. And if this is go forward debt that they're going to have to live with. So private equity does a lot of that negotiation, but the company does get involved a little bit, and taking a look at those documents, and particularly as it relates to conditionality, meaning the conditions on which the debt is going to be issued, and making sure all of those boxes are checked so that the debt will actually be issued on the closing date. And but I think the second big lift for company counsel, Wachtel in this case, is the proxy and the shareholder vote. So the proxy statement is a disclosure statement. It's a disclosure document that gets filed with the SEC. It gets sent out to shareholders of Aramark, and it explains the transaction in tremendous detail. And so it includes a background section that basically outlines the history of the deal, starting with very early and initial conversations, and the steps that the board took and that management took, and conversations that were had, and drafting sessions that were had, and meetings that were had, that walk shareholders who were not participating in the transaction this whole time, walks them through what happened so that they have an understanding of the level of diligence and care that the board and the company undertook to get to the best deal. And it also talks about any other bidders, and any other parties that put in offers to purchase this company, and why they were not desirable, or if the company didn't shop itself, if they just struck a deal with someone who came along, and the reasons why they might have made that choice as opposed to running a competitive auction process. So the proxy statement includes all of that information. It includes the deal terms, a summary of the merger agreement. It includes a summary of the fairness opinion. It includes the rationale for the transaction. It includes information about all of the change of control payments or other things that are going to go along with this. So many times upon a change of control, you have executives who have employment agreements or otherwise, that a transaction like this would trigger payments. And so all of those, to the extent they exist, would be described so that shareholders understand fully. And in this case, there was a significant disclosure on Neubauer and his involvement in the transaction, and what role he played in the negotiations, which was very little. We had this special committee who did a lot of that, but he was wearing two hats, right? He's the chairman and the CEO of the company that's being sold, but he's one of the people buying it. So a lot of disclosure needs to be had in that respect. And so it outlines all of this for shareholders so they can see the conflicts, the payments, the fees, the analysis of the price, the background. It goes on and on and on, so that they can make an informed decision about whether or not to approve this transaction. And so you prepare your proxy statement, which is a huge undertaking. You file it with the SEC, and many times the SEC gives you comments back and has a lot to say about, has something to say about your proxy statement. And so there may be some volleys with the SEC that require revisions of your proxy statement. Once that gets cleared by the SEC and they say, okay, we're okay with this, you can go ahead with your meeting, Then you send that out to your shareholders. You hold a special meeting. You have to get the vote, whatever the requisite vote is, 50%, 2/3. And so Wachtell is running that process. Oftentimes they'll hire a proxy solicitor. So there's firms out there, non-lawyers, who solicit who solicit this vote. And so they'll be calling shareholders and making sure shareholders are on board with the transaction and are voting their shares, so that you can be sure that you actually are going to obtain and get the vote that you need. And then I mentioned before, there's plenty of contracts that you need consents from in order to do this transaction, because they either have a change of control provision, or people want to make sure that the largest vendor or supplier or customer is on board. And so Wachtell, on the company's behalf and working with the company, would manage that entire process, which can be a lot depending on the company, how many consents you need to go out and get. And how hard the vote is to get. It depends, not all shareholders are on board with things, even though they look on paper to make sense. And so that's a big lift. And then they also get involved in all of the post-closing arrangements, because their management at the company is going to still typically remain management at the company post-closing. And so they get involved, and they know the employees, and they know what the current plans are and what the go forward plans should be. And so they get involved in all of that as well. And I mentioned that the competitive auction process, if a company did put itself out for sale competitively, where they were soliciting a lot of bids from a bunch of different potential buyers, Wachtell would be managing that process. And that can be a very, very big project, depending on how many bidders you're entertaining. You start with non-disclosure agreements, and there could be dozens of those that get negotiated and signed. Then you drop down and you get some bids in. Then Wachtell would be helping compare those bids and markups of various merger agreements to figure out whose bid is the best, and advising the company about what path to go down. So that's Wachtell. So next we have Skadden. Skadden was representing Aramark's board as a whole, and the reason there is because in a transaction like this, and really any transaction has, at a company with a board, they have fiduciary duties. But when you're taking a company like this private, and it's this high profile a deal, you need to make sure that every I is dotted and T is crossed, to make sure that the directors are fully covered and are fulfilling their fiduciary duties. And depending on the nature of the transaction, their duties are, have varying levels of responsibility. There's a heightened standard, and then there's kind of your just general business judgment standard. But Skadden would have been responsible for, and I'm sure they did, advise the board on their fiduciary duties and outlining for them. You oftentimes give them a memo, a presentation about what their fiduciary duties are. They also, in conjunction with that presentation, summarize and present the terms of the transaction, and make sure that the board is fully informed, has received all of the documents, understands the documents, has the summary of terms, understands the duty and their responsibilities. And so that would be Skadden's function, is to attend all of those board meetings, answer questions from directors, and make sure that the directors are protected and have limited exposure and liability here. Next, we go to Cravath. And as I mentioned at the outset, Credit Suisse was the financial advisor here. They were charged with giving a fairness opinion and putting that fairness opinion in the proxy, and telling the board and the shareholders. The fairness opinion is issued to the board, and the shareholders see that in the proxy, whether or not the transaction is fair to the shareholders from a price perspective. And they are represented by Cravath, and Cravath would help them draft the fairness opinion but probably more significantly drafting the description of the fairness opinion and the process that they undertook, that Credit Suisse undertook to get to that fairness opinion. So a fairness opinion is, 2 pages, call it, saying we did this analysis, these are the assumptions we've made, and we think that this transaction is fair in all material respects to the shareholders. It's two pages, it comes down to 1 sentence. But in the proxy, it gets described in much more detail, and the financial models that Credit Suisse used to determine that, and the other pieces of the puzzle that they looked at to get to that conclusion are outlined in the proxy statement. And so Cravath gets very involved in drafting that disclosure, because there's liability for Credit Suisse too here, which is why they need the lawyers, because they're going out and they're putting their neck out on the line in some respect and saying this is a fair transaction and this is the work that we did. If you have shareholders that decide, actually, there's a flaw here, we don't agree with this, we don't think it's fair, and they bring a suit, Credit Suisse is the one who has said at the end of the day that this was fair. Granted, the board ultimately decided, but they have some exposure there. And so they need to make sure that the disclosure around what they did and the conclusion they came to is protective of them. So next, and just to go back, because I don't think I appropriately covered, we talked about what junior associates would do at Wachtell in terms of the mergers agreement and helping with diligence and the schedule. So I think, and certainly drafting the proxy statement is something that requires a lot of work, and junior associates would get involved there too. And from a third-party consent perspective, junior associates would be working with the company to draft those letters that you get back as the consent or the consent documents, keeping track of all of that. So there's a lot of junior associate work at Wachtell too. At Skadden, usually it's a partner who's presenting to the board and doing that work, but the partners who are doing that rely on the junior associates to help draft any memos that go to the board, to summarize the merger agreement and the other deal terms, to check case law, and to make sure that the fiduciary duties memo is up to date with the latest and greatest and reflects any case law, because directors are a smart group of people and they also follow the law and legal developments. And so you don't want to be caught flat-footed at a board meeting when a director says, well, what about this recent Delaware case? So junior associates would get involved in helping prepare those summaries and those memos that would either go to the board or be used by the partner in presenting to the board. And then at Cravath, similarly, the disclosure in the proxy would be something that junior associates would get involved with as well, since it's largely a drafting exercise and making sure that the document reflects the work that was actually done by the client. Okay, so on to Shearman and the special committee. I mentioned at the beginning why we needed that, because you want a group of truly independent folks recommending the transaction to the full board and ultimately to the shareholders, and making sure that they're doing the appropriate work and analysis. So much like Skadden, Shearman is advising the special committee on their fiduciary duties, doing the same thing. So if you were a junior at Shearman, you would be doing something very similar to what the juniors at Skadden were doing in terms of updating your fiduciary duty memo, reviewing the merger agreement and schedules and summarizing those, and the financing documents and all of the deal documents, and summarizing those for the special committee, so that they could analyze this deal and make a good recommendation. So those roles are very similar when you have both a board that's being advised and a special committee, a subset of that board that's advising and recommending a transaction. And then you have Sullivan that was involved here too, because Neubauer, who as I mentioned was the chairman and the CEO, was also going to continue on as an investor, and so he was participating in this leverage buyout. What is a management-led leverage buyout, because management is also participating and initiating this. And so his counsel, because he's going to be an equity investor, his counsel at Sullivan would be reviewing the equity documents. They would also be involved in the post-merger governance documents. So much like we talked about before, Joe Neubauer was going to continue on as the chairman and CEO of this company, and he was also going to continue on as an investor. And so he's obviously interested in both capacities with what this company is going to look like on a post-closing basis, and making sure that employees are going to be receiving, the same types of benefits, and what salaries are going to look like, and how this company is going to be run, right? That's what a CEO's function is at the end of the day. They're the captain of the team. How this company is going to be run post-closing. And so they would have been working with him in conjunction with, talking to Simpson about what their collective view of how this company was going to run post-closing. And then obviously he's concerned about his equity investment. And so similar to the private equity, he has his own set of equity documents that govern the terms of his equity investment. There's also his own post-closing compensation package that needs to get negotiated. And so, he has an employment agreement and an arrangement, and he gets paid in his capacity as a CEO of a company. And so that arrangement needed to be negotiated. And so Sullivan would represent him on that as well. And then Sullivan's, biggest role probably was making sure Joe stayed out of his own way, because he was a current chairman and CEO. He was then going to become an investor. He was also continuing on as the CEO post-closing. It's just ripe with conflict. And making sure Sullivan's, big job on this was to make sure that Joe was not wearing too many hats at one time and playing both sides, because that could really throw a wrench in the process. You want your process to be airtight so that you're not giving any room to disgruntled shareholders or activist investors to say, hey, your process was flawed. You had this guy on both sides of the table, ultimately looking out for himself and not for the shareholders as a whole. And so he really, your process needs to be solid. You need to make sure that independent folks are on opposite sides of the table, and that you don't have one person, and he's a big personality, kind of controlling all aspects of the deal to the detriment of the public shareholders here. And so Sullivan would have been providing a lot of guidance to him as to where he could get involved, what he should weigh in on, what he shouldn't weigh in on, and so forth on various parts of the deal. And then you get to us. So we represented the financing sources. And sorry, just to go back, I forgot again here. I think I covered what junior folks would do at Shearman, but at Sullivan, junior associates would get involved in the equity docs, but probably more importantly on the post-closing stuff and the governance, and any changes to the policies or that we're going to go on. When you switch from being a public company to a private company, all of a sudden you have a lot less that you're required to have, and the terms of those documents may change in some way. And so, rejiggering what the post-closing governance package looks like from a documentation standpoint, in terms of bylaws or policies or codes and other things like that. And you probably would also be doing some research on the conflicts point and making sure that the partners who were probably the ones primarily dealing with Joe were up to speed on any recent cases or issues or court findings around conflicts or management-led buyouts, and things like that. And if you were working in an exec comp area, you would also probably be getting involved with his post-closing employment arrangement. And so then you come to Cahill, and we were representing the financing sources, as we oftentimes do. And, the financing sources, we work on the commitment letters. at the beginning of the transaction so that they know before they sign the merger agreement that the money will be there when they go to close. And so that's the heavy lift at the beginning. And then you move on to negotiating the actual deal documents and working with our clients to structure the financing and what's market, what's not market. Cahill does more financing work representing the banks than any other firm in the world. And so we see a lot of deals. And so our clients routinely rely on us to say, hey, this is what we're seeing across, 5 or 6 different banks and industries and so forth. So, so we advise them on structuring the financing and including market provisions. We worked on the commitment letters. We work on the debt documents themselves. When you're doing the debt piece of this, you also need to be reviewing. You're not negotiating, but you're reviewing the merger agreement and the disclosure schedules. Junior associates, there's diligence that's done on the financing side, obviously, because our client, the banks, want to know that they are lending to a credit-worthy institution. And so the same level of diligence, diligence is also done on the financing side. It looks very different than the diligence that's done on the M&A side, because on the M&A side, you're evaluating a company and deciding whether or not you want to buy it and what could cause you headaches down the line and where are your vulnerabilities. On the financing side, you're doing diligence from a very different perspective. Your client wants to know, is this a credit-worthy entity? Is there some smoking gun? Is there some reason we shouldn't be lending to them? What is their business? What do their financials look like on a go-forward basis? How much debt could they really support based on their cash flows and other financial metrics? So it's a different type of diligence. It's not any less intense, but it's just looking at those same documents and materials from a very different perspective. So junior associates at Cahill spend a lot of time doing that diligence for the financing sources. And providing downloads and recommendations about, well, maybe we should add in a covenant about this, or maybe we should tighten up this ratio based on something that we're seeing in diligence or otherwise. So we take a look at, the diligence, we do all of the financing documents, we look at the merger agreement because it's relevant to the financing sources because you want to know what the terms of the merger are. You want to know what representations are being made. And you advise your client, like you do in all cases, on potential liabilities and exposures and disclosure items, because the terms of the debt is going to be disclosed as well. So we get involved in all of those same aspects, but just in a slightly different way. And junior associates get involved in all of that.
Casey, I have a question here.
Sure.
So this question is, do the commitment letters usually get done before the signing or in between time of signing and closing?
Yeah, so the commitment letter, you sign the commitment letters at the same time you sign the merger agreement, which is that first line in the process. I could probably get back there quickly. So if you see, and I don't know if you can see my mouse, but you strike a deal and line up the financing. And so you'll see right here, the merger agreement is signed and the commitments are signed, so that when you sign the merger agreement, you have the money will be there. And then you work through these other processes to get to a closing. And then where was I? I think I was here on the shareholder vote. Okay. And so, so after you have all of this negotiated, you've signed your merger agreement, we have our fairness opinion, we have all of this stuff. Like I mentioned, we have the proxy statement, which needs to get prepared, and we need to go out for a shareholder vote. And so buyer and seller primarily take responsibility for drafting this proxy statement, mostly by the seller. And but it gets reviewed by everybody because everybody's name is going to be in there, and there's going to be disclosure by everybody. As I mentioned, it gets reviewed by the SEC. We have proxy solicitors who go out and call, dial for votes, or dial for dollars, really, and try and get this shareholder vote locked up. And so you got to make sure the proxy's solid. and you need to make sure that that you're going to be able to get the vote. Because if you don't get the shareholder vote, you don't have a deal. Your deal's dead. So all parties work on that proxy agreement, and then fingers crossed you get your vote, and you move forward, and then you close. And just like that, you wake up one day and someone else owns this company. So, there's conditions in the merger agreement, there's conditions in the financing, all of those at this point will have been met, the shareholder vote usually being the biggest of them. And there's a bunch of certificates and extra documents that junior associates get very, very involved in. A closing checklist for a deal like this could be 40 pages of documents easily. And so there's just a lot of paper that needs to move, a lot of signature pages that need to be collected, a lot of resolutions that need to be drafted, and things like that. And so all of that, goes down to the junior associates, the consents that I talked about, notices that need to go out, approvals that need to be gotten. All of that is a tremendous amount of work to get a deal like this closed. And so junior associates are relied on very, very heavily to bring this home, because once the deal's negotiated and signed, it's really just a lot of paperwork that needs to get done. And from a cost perspective, clients, don't want to pay partners to draft certificates. And so junior associates spend a lot of time getting a merger ready for closing. And this page, for people who are interested in the debt world and how you come up with $6 billion of debt, and the debt piece of all of this, JP Morgan goes out and gets a bunch of people to participate in this transaction. That JP Morgan's not the one putting up $6 billion on their own. So they gather a consortium of folks who are going to participate in this in some way. And as between Cahill and Simpson, who is representing the private equity, like I mentioned, Aramark gets a little involved, but not really, because private equity is the one who's going to own this and wants to make sure the terms of the debt work for what they are planning to do with this company post-closing. And so Cahill and Simpson spend a lot of time negotiating all of the documents that you would need either for the loan or for the securities offering, which requires an offering memorandum, which junior associates would spend a lot of time reviewing and getting involved in, because it's based in large part on the diligence. And so we rely on junior associates to do, to review the credit agreement disclosure schedules, to review the offering memorandum, to work with the auditors on the comfort letter, so providing assurance that the numbers that are in the offering memorandum are correct. All of the security documents and pledge agreements, the checklist on just the debt piece of this is probably 10 or so pages long, and junior associates spend a lot of time on all of those documents, and in particular, again, the diligence piece, and the disclosure piece. So that is a deal, a very complex deal with a bunch of different parties. But I hope it gives you a sense of all of the things you can do as a corporate lawyer, right? You could have been on any one of the 6 or 7 parts of this transaction and been doing a bunch of different stuff. Or you could be the go-forward counsel and doing the non-transactional stuff. So, there's kind of something for everybody if you like transactional work, or working with companies, I should say. And it's all really interesting and fascinating. And, at the end of the day, you're helping companies operate and function, and you're helping the capital markets continue and the economy keep going. And particularly now, we're working on a lot of deals where companies are saying, thank you so much for helping us secure this financing. Otherwise, we would have had to shut down or had to lay off a bunch of employees. And so, corporate lawyers don't always get, a good rap. But I think the work that we do ultimately is very important, not just for the economy generally, but for individuals. When you drill down to it, a deal like this saved jobs and people's livelihoods. And so I think it's important work, and it's a variety of work. And so there's a lot of different ways that you could go in a corporate law function. So hopefully I sold you on that. Were there any other questions, Mary?
I don't see any other questions in the chat, but I would invite our participants, if you do have a question, just go ahead and unmute. Alicia, you have your hand raised.
Yes. So I have a question. So usually in terms of like corporate work versus like litigation, is usually that corporate work is much more fast paced as opposed to like the litigation side, and deals like this are, come about quicker. Like, so how long would this type of deal, where it's like over $8 billion on the line, like how long did that take to manifest itself? And then is that the typical like time frame, where there's like weeks to go about all of this for it to become a private company again?
Yeah, so it could vary wildly. So this deal in particular, by the time the lawyers get the call, the bankers and the private equity folks have already done a lot of work in terms of deciding whether or not they want to do this deal and at what price they want to do it. So I can't really speak to how much pre-work they did by the time they call the lawyers. But by the time they call the lawyers and they are, ready to move forward with a transaction of some sort, you could do a deal if you didn't need shareholder approval. So let's put that piece aside. If you didn't need to file a proxy statement and get SEC clearance and get shareholder approval, I did a deal similar to this recently in 2 months, which is very fast. It's a lot to do in 2 months' time, but you can do it. If you need shareholder approval, and so you have to put together a proxy statement and you have to hold a special meeting and potentially wait for SEC review, that process could take longer. The SEC process, I worked on a deal recently. We did a proxy. I thought for sure we were going to get reviewed. The SEC didn't review us. So in 10 days after you file it, you clear and you can hold your meeting. So you can move quick. Here, it wasn't as quick. But I would say a large transaction, any transaction similar to this, that you need a proxy statement, you need a shareholder vote. I would say you're probably in a 3 to 6 month window. You also have some regulatory approvals. Again, in a private equity transaction, you usually don't have any Hart-Scott issues, antitrust issues, but if you have two strategics, that could be a problem. We've seen, I don't know if anybody followed the Broadcom-Qualcomm transaction, but we were involved in that one too. And that one got a lot of scrutiny from the regulators, and was also had a bunch of other hair on it. But, transactions, I think without any sort of hair on them, limited SEC review, not a lot of regulatory issues, you could do something like that in 3 to 6 months. The others, it takes longer. I worked on one that it was a very easy negotiation, but we needed, it was an electric company, and so we needed a bunch of approvals from various states. And that one, even though we got shareholder approval right away, we still had to wait another 9 months to get the regulatory approvals. And so it was like a 12-month process almost. But again, it varies wildly depending on the dynamics of the deal. But everyone always wants to get the deal done as soon as humanly possible. So from a lawyer's perspective, it's going to be breakneck speed until there's some third party who holds you up, and it's usually the government. But overall, corporate work is way faster than litigation, and way faster pace. We don't work on things for years. We work on things for weeks or months.
Terrific. Jess, I see your hand is raised.
Yeah, I just was wondering if you always knew that this is what you wanted to go into, or if not, how you wound up following this path.
Yeah, so No, I did not know that I wanted to be a corporate lawyer. So I was poli-sci undergrad, not a lick of finance or, you know, any sort of type of background that is helpful to this type of practice. I worked in between undergrad and law school. I was an HR manager at GE and worked with a lot of labor and employment lawyers who I thought were really cool. And so I decided to go to Albany because I was working at GE in Schenectady, and decided I was going to go and I was still working and was going to be a labor and employment lawyer, and maybe potentially go back to GE and be a labor and employment lawyer. And my 1L summer, I left GE and went and worked for a labor and employment law firm. And I hated it. Oh my gosh, it was the longest like 10 weeks of my life. And I didn't hate the substance of it. I still liked the labor and employment aspect of it, but it was litigation. And I determined very early on that summer that I was not a litigator. And to Alicia's point, it was because it was so slow. I did not see a single thing resolved all summer. I spent my summer researching and writing, and it was not for me. The pace was way too slow. I had ants in my pants, and I just didn't like it. So when it came time to interview, heading into my second year, I interviewed with a bunch of firms and knew I didn't want to be a litigator. But didn't know what corporate work was at all, but figured that's where I needed to be by default because I was not a litigator. And so I went into that interview process really not being able to clearly articulate what I wanted to do, which is fine. For those people who are out there interviewing, is totally an acceptable answer that you don't know yet. And I interviewed with Cahill, and Cahill's system, we have a free market system, which is a bit unusual in big law in that you're not in a group, really. You don't have to pick a group initially. And there's no formal rotation system. I wanted to go to a place I was never going to have to do litigation. And so a lot of summer programs require you to rotate through various groups. And I was not of interest to me at all. And so Cahill's system was appealing to me because I wasn't going to have to do any litigation. They had a tremendous corporate practice. I was going to get to learn and see a bunch of different things to see if I liked it. But ultimately, at the end of the day, I mean, my decision was based on the people I met, and would be my recommendation across the board is that you need to find a place that's comfortable. You know, as you can see on this chart, and it stands true, you know, at a bunch of firms, you know, firms do a lot of the same stuff, right? The stuff that people do at Cahill are the same stuff that people do at Simpson or Skadden or others. So, you know, we were all involved in this deal and doing slightly different, but mostly similar things. And so, but I interviewed with those other places and they weren't a fit for me. I just culturally and personality wise didn't fit. And so that is not a direct answer to the question, but I would encourage you, if you are out there in the market, to make sure you find a place that fits for you, that feels comfortable, because you know, the substance is important and that you're doing work that you're interested in. But I think to have longevity as a lawyer and to be content as a lawyer, there's a lot more that goes into that. But I'll save that for another talk on another day. But I did not know until I tried litigation that I wanted to be a corporate lawyer. And then once I went to Cahill for the summer and did corporate work, I loved it. The pace of it was exactly what I was looking for and was well suited. You know, I worked on and closed a bunch of different deals that summer, and that's continued on in my practice. And so it was a little bit trial and error, and I had no previous business or finance experience. I kind of just learned it on the job, and that'll be the case in most corporate practices, unless you have some sort of corporate or finance background. And even then you'll learn a lot of it on the job. And not to be critical of law schools, but I just, you know, law school is not set up to teach deal work in large part, and corporate transactional and non-transactional. So you'll learn a lot of it on the job, but it would encourage you to try it because I don't think you need any experience, and sometimes you just need to try things to figure out what you don't like.
Terrific advice. Thank you so much, Casey.
Yep.
So I think we're actually we're at 1:15 now, and I want to be respectful of your time. I'll just ask really quickly, I don't see anything in the chat and I don't see any hands up. So I'll give you all one more minute to raise a hand or pose a question.
And if something occurs to someone later, you know, feel free to reach out to Mary or reach out to me directly. I'm happy to chat or answer questions. So this is not your last opportunity.
Terrific. Well, thank you, Casey, so much. I learned so much from listening to this presentation. And I see in the comments, we have a lot of students grateful, and Professor Rayhan was on earlier as well and expressed her gratitude. So thank you so much.
Of course.
We will be sending out a survey to all of our attendees. We would appreciate it if you would just take a few minutes to fill it out and get it back to us. And this presentation has been recorded and will be made available to the student body.
Awesome. Thank you guys. Have a wonderful holiday weekend and stay safe. And please feel free to reach out if you need me.
Thank you.
All right. Thank you all. Bye-bye.